Welcome to the latest episode of the Alternative Litigation Strategies podcast. I'm your host, Kevin Skrzowski, a director at the litigation consulting firm Certum Group. On this program, I interview esteemed members of the bar and legal industry experts from all over the country on cutting-edge topics of today that impact the litigation industry. And today, we are going to discuss the biggest concerns and expectations that attorneys have when working with class action claims administrators. And I am really pleased to be joined by veteran settlement administrator and CEO of Fidexis Administration, Jim Prutsman. Jim, welcome to the program.
Thanks, Kevin. Glad to be here.
Yep, good to see you again. So we're going to cover a lot of really interesting topics today, including the role and value of a claims administrator, combating fraud in settlements, navigating notice programs, technology, call centers, and the impact that AI is having on them. And then we're going to wrap up with some discussion around ethics, finances, and transparency. Are these the hottest topics that you're seeing today, or how did you come up with this list?
Yeah, no, thanks, Kevin. So, originally I was thinking about what we could talk about, and then, it occurred to me that who cares what I think? What really matters is what do our clients and customers think about. So I went out and interviewed several attorneys that had recent settlements, some that I administered, others that, other administrators had been retained. And I asked them, I said, look, what do you wish that you would have asked the claims administrator prior to hiring them? And that's really where this list came from. And it was interesting, Kevin, because there was really a natural set of categories and questions that the folks had, and being able to kind of see those trends and patterns and organize them in a way that hopefully makes sense. That's really, where this came about.
So that's great. So this is directly from the mouths of several clients who are class action attorneys. So
yeah, these are their questions.
These are their questions. Yeah, that's great. So let's get started with the first section, the role and value of a claims administrator. Now, this is something that I know is tough to establish with any consultant in the industry, but it's how do you get them to change their perception and shift it from thinking that you're just this vendor to a true partner or advisor in a litigation matter?
Yeah, I think they raise an excellent question and an excellent point. Look, cost matters. Anybody that says that it doesn't is simply just not shooting straight. But beyond, providing a good value and a competitive price, I think it really comes down to a number of things. One of them is, who's your point of contact? Who is it that, if something is needed, if something goes bump in the night, who's your point of contact? Who are you reaching out to? Are they able to respond to your needs? I think that when you're seeking to provide services at the lowest possible cost, that work's being pushed down in the organization and being pushed down to the lowest cost person available to, hopefully sustainably do that work. But the reality is that when an attorney who's invested, days, weeks, hours, many cases, years of their life in a settlement, and now they need something, who's available to answer that question, and who's actually doing the work, who's performing that day-to-day work, what's their experience level? And then I think, part of it also comes down to, what's being outsourced, how is it being outsourced, where is it being outsourced? Look, we outsource an awful lot of work that is done, but they're with, partners that we trust and have used and others used for years and years and years. And we have, the same expectations with regard to direct lines of communication and getting quick and timely responses. So, that's the same thing that attorneys and their staff should expect, that, they're getting quick, accurate, crisp answers to their questions and timely responses. So, I think that's something that it transcends just price it's responsiveness and accuracy. So.
And I think that's right. And I know we've noticed that as well when we're working with some of our clients and asking why people maybe switch from one provider and come over to us for any of the myriad of services that we offer. And it's, well, I went there and the person I met who really sold me on the business, we never saw again.
Yeah,
And
they bought a great cocktail, but then
yeah, then they didn't have any dinner. Yeah,
yeah.
so I think that's great. So I know there's a lot of issues and pitfalls when it comes to administering cases that you have to work diligently to avoid during the process. So how do you work with attorneys prior to the finalizing a deal to make sure that you avoid some of the common pitfalls, and what are some of the common problems that arise in administration?
Yeah, so I would say that it's important, in this theme of partnership and being a trusted advisor. There's several elements that are really important to look at, and some of these we'll flesh out a little further in the discussion. But important things like the timeline. Is the timeline that's being proposed for the settlement reasonable? Can everything be completed in that timely manner? Is that negatively going to affect people's due process rights? What does that notice plan look like? What are the elements of the notice plan? And how long are they going to take to execute? And again, it feeds back into not only the court's expectations, but also the due process requirements. And, do people have enough time to make a decision as to what they want to do? Whether it's participate, opt out, object, or are they aware of all those rights? I think that also, do you have a plan for, what's going to happen with the claims? I think more and more of these cases are seeing, unusual amounts of claim activity. And do you have a solid plan for what's going to be done there? Do you have a contingency plan? Those are all important things to work through, I believe, in advance of, finalizing those documents and then sending them off to the court. And that's something that a seasoned administrator can assist with. It's not that they want to renegotiate any settlement that you've been working on. We understand the hours and time and labor that goes into, getting to a settlement. And that's not really the point. The point is to make sure that what's being proposed, can be executed to meet those expectations of not only the parties, but certainly the court. So, those are the things that we would encourage parties to reach out to an administrator early and talk about. And just having a good working timeline is invaluable, and understanding, are we on track? Are we off track? And tracking back to that timeline that's been developed is probably one of the most critical components of a successful settlement.
Yeah, I think that's a pretty big list, and I think that timing and managing expectations is especially critical. I agree with you. I think that's kind of par for the course for everybody that's involved in a matter, including the client who's paying the bills. Is how long is this going to take? And you always want to, if anything, under promise and over deliver in that area.
Absolutely, Kevin. I think that the thought, if you want to send a shiver down the party's spine, it's this notion that you need to go back to the court and tell them that there needs to be more time, or there's a delay, or
more time, or more money, or more.
It always equals more money.
Yeah,
time is money, and it always is. So it means that something's happened. So again, I mentioned briefly a contingency plan. What if? What are you going to do if? So making sure that you've got that accounted for as best you can, and try and prevent the blind spots that may occur.
Yeah. So. Yeah, I know. I was working with a head of litigation at a big company. He's been there almost his whole career. And we were working on a case and we were with an administrator, and he said, "Don't make me go back to my GC and ask for $1 more. It's like a death sentence." So it's important. It's important to the clients, right? So, yeah. So in terms of
It's their reputation as well as ours. So,
oh yeah. So in terms of delivering like really high value, and this is something that I guess one of the attorneys you spoke with brought up, and it's something I never necessarily thought of before. But like you're a seasoned administrator, so you've been around a long time. You've worked on settlements in a lot of different courts. How important is it to have intel on a particular judge and jurisdiction to make sure that a settlement gets approved? And how do you like impart that knowledge as a value-based resource to your client and leverage that for your clients?
yeah. It's a really great question that they came up with, and I think that it's an area that a seasoned practitioner can really add value to their clients, and a seasoned administrator can add value to their clients. And it comes down to a matter of what are the court's expectations. There are judges that have been around a good number of years and have seen a whole lot of settlements. And you can see patterns develop of what they're looking for, what they're asking for. Sometimes you have a new judge, but even at that, what's their background? Where did they come from? Have they been involved in settlements before, or is this their first class action? And so if it's their first class action, then I think you need to develop your own checklist of what is it that they could ask. And there's some really good guidance out there that's available. Personally, something that we look at is, one of the most well-regarded courts in the country is the Northern District of California. And they've put some very crisp guidelines as to what their expectations are when the parties come in for preliminary approval. And I will tell you, Kevin, that lately I've seen folks that have cases in other jurisdictions still using those Northern District guidelines as a way to prepare for preliminary approval. And, there's a couple of approaches that you can take. One is, add it all into your documents, add it all into the papers that you're filing for preliminary approval. Other is, put some in there and then be well prepared with the answers to the others. If there's a hearing, an in-person hearing or something of that nature.
Yeah.
But I think it's important to think ahead of what questions they might ask. Again, I would really recommend that people drill down in on those Northern District guidelines. It's a great starting place. But I think that, back to the original question, go back and look and see what other settlements, this judge may have approved, what questions they've asked.
Or more importantly, rejected. Which ones have they rejected?
Which ones have they rejected and why?
Yeah.
So I think that you want to be well prepared. Nobody wants to have to go back multiple times for preliminary approval. And the same is true with final approval. You may have gotten the preliminary approval and figure you're all good to go, but you need to go back and look and see, what has happened. Have they given final approval? Did they make the parties come back? What happened? And a little bit of prevention goes an awful long ways. I think there's some real key points that you're going to see there kind of over and over again. And it's like, what's happening with, the funds, what's happening with the interest earned on the accounts. Why is there a claim process? Why are we even bothering to have a claim process? Do you know these people? Could you just pay them? And what's the answer to that question? Things like notice. Notice has become increasingly important. Where is this data that you're using to send direct notice? Where did it come from? What's being done to improve it? And we can talk about that here later. I think there's some important tools available that people should really take a look at. But I think you have to have a good, solid plan, going in to that preliminary approval, so that when you are being asked questions by the judge, that you've already thought through and worked through and dealt with those. So, I think that it kind of ties back into one of the original questions of making sure that you have a seasoned partner to help you with these things and work through these things? And have they been in front of this judge before? Have they been in this district before? What was that experience like? And, I think we can all work together to ultimately come up with better solutions, better settlements, and better resolutions.
Yeah, I would agree with that. And I think that's all really, really great advice. So let's move on to our second section. And I know this is top of mind with so many people I've spoken with over the last several years. And it's combating waste, fraud, and abuse and ensuring data integrity. Now, I know when people really started to focus on this a couple of years ago, there were major concerns about just bad actors making fraudulent claims in the administration process and really driving up cost. There were some foreign bad actors. We were working on a settlement once, and there were people from Russia and China that were just clicking on the button to get paid thousands, tens of thousands of times. And there were just some other than domestic issues as well. So today, what are you seeing as the biggest threats to the effective administration of class action settlements in terms of waste, fraud, and abuse?
It's such a relevant topic, Kevin. You're exactly right. I would say that these days I don't have a single conversation with a practitioner that doesn't have some element of waste, fraud, and abuse as a part of that conversation. And, we're concerned, they're concerned, the courts are concerned. I think that, has been in the past this notion that, well, maybe it's a common fund settlement. I'm not concerned about it. We just put forth the money and we went on about our way. We don't care what happens. We don't care that fraud exists. I just think that that's a very wrong headed position to take on it for several reasons. One is, as you alluded to, these could be foreign actors. And, where are those funds going? I don't think that anybody wants any notion that their dollars are being spent to go do something nefarious. And the possibility is real.
And you want the class members to get paid. They're real class members.
That's right. That's right. These settlements exist for a reason, and it's to, put money back into the hands of actual customers, clients. It's not to just disperse funds willy-nilly. I mean, if that was the case, then, why even have a settlement process? So I think that that's a real concern. I think that it continues to evolve. We see that it's something that we invest a huge amount of time and money into combating. Just when you think you have a handle on it, well, then there's a new way into the building. And so it's just constant diligence that needs to be applied to it. I think that there's an awful lot of, settlement promotions out there. I think that there's probably been, some of the industry has utilized that in an effort to try and boost claims in cases that otherwise may not have had adequate participation in. But I think it's spawned a whole industry of fraud. Whether it's the third-party filers that, they're getting people to sign up for these things, and, were they truly customers and purchasers of the products in the instance of consumers? Real concerns. You would like to think, Kevin, that when you have a closed class, that this should be a very simple thing to do, right? We know who the people are. They were people who were customers for this doctor's practice, and their data was breached, so we know exactly who they were. They visited, Dr. Jones over here. Well, think about it for a second. That data was stolen, and we've seen this. Now, the stolen data is being used, Kevin, to file claims in the settlement. So they're doubling down. They're doubling down using that stolen information to participate in class action settlements. We have evidence of that. So you have to be on top of your game and understand where the information's coming from, what's been happening with it, how is the fraud being analyzed, or potential fraud being analyzed by the settlement administrator. And are they taking responsibility for that? Or are they trying to put that back on you? Are they saying, well, you tell us what we should do here? If that's the answer, what is their role? Their role really needs to be safeguarding and protecting the interest of the class. That's the job.
Right.
And they need to do the job. So, there's a whole lot of tools that we use. And again, we do spend an awful lot of time and money working on these things and identifying patterns of fraud. I think that there are folks that take a very simplistic view of this, and I think there are folks that try and shirk their responsibilities in it, and that's just the wrong approach. Again, the court is relying on the parties and the settlement administrator to adjudicate these funds appropriately. And I think you have to have a certain amount of confidence that that's being done appropriately. And those are the questions. We get back to, what questions should attorneys be asking? What methodology and how are you preventing fraud, waste, and abuse? And, who's responsible?
Yeah. So speaking of that, how do you identify a valid claim from a fraudulent claim? Like, what are some of the red flags that you see?
Yeah.
And then what are some of the safeguards that Fidexis puts into place to try and prevent that? And then I guess the third part of my question would go back to another comment you made about those methodologies that you put into place to combat waste, fraud, and abuse.
Mm-hmm.
Are they different for claims made settlements versus common fund? And without you giving away your
Right.
secret sauce,
Sure.
but let us know. But first of all, how do you identify? I know in some cases we worked in, we saw that 15,000 IP addresses were tracked back to China, or they're using really weird old email addresses. They're using Arrows. They're using AOL, which no one uses anymore. So you see 2,500 AOL. When's the last time you saw an AOL?
That's odd.
And you're like, gee, maybe I should look into this. So
that's right. You think those CDs are still floating around out there, Kevin?
Yeah, it's like you get in somebody's car, they have an 8-track player. Something's wrong with this guy.
That's right.
So what are the red flags? And what are your safeguards to combat against them?
Yeah. So I think that it's a matter of not just any one tool, but deploying multiple tools and looking at it in a multi-layered approach. I think that if you take and are simply relying on IP addresses and that's your main tool that you're using, I think that you have, you better ask some harder questions, because that is simply not enough and is going to do everything from raise false positives to just complete blindside and blind spots with regard to fraud, waste, and abuse. Mm-hmm. You need to look at being able to deploy big data. You need to be able to look at multiple vectors. So whether you're looking at the payment information and then combining it with the claim information and analyzing everything from addresses, physical addresses, to email addresses, and do all these things make sense? To your point, isn't it odd that somebody's using, these outdated domains for email?
Yeah.
And how does that overlay with the payment information? How does that overlay with the address information? There's a lot of stolen data out there, and the bad actors have access to it, and they're using it. And they're using it so you can't just say, well, this person exists, right? We know that this person, Mr. Johnson, lives in Miami, Florida. He's a real person. Well, this claim should be good. That's again very short-sighted. Does the data all line up? Is where the claim coming from match the payment? Does the payment match the name? Does the name match the claimant? I mean, it's all multiple layers that all have to be looked at very carefully, and it can be done efficiently. You know, what we're not talking about here is having an individual sitting there with a spreadsheet going through these things and flagging them, but what we're talking about is intelligent tools, intelligent algorithms, again, utilizing big data, analyzing it from multiple standpoints. And it's, again, something that requires significant effort, planning, and resources. So, you know, those are the things that you need to look for. And those are the answers that you should be getting with regard to, you know, how these claims are being processed. You know, again, this notion that it's a closed class, we're good to go, that's dangerous. It's
not necessarily, because identities are being stolen left and right, and data is being stolen left and right. So that person might be real, and you might be thinking you're sending it to, you know, Bill Smith in Buffalo, New York, and you know it's halfway to Russia already.
That's right.
So, you know, so now, and so go back to our previous point. You need a lot of experience to develop and create and craft all these methodologies as well. So
you do, and I think that that's an important point, Kevin, is that, you know, how long have they been doing it? You know, what's their track record of success? Who's responsible for it? So you know, it gets back to, you know, being a trusted partner, of being the right person for the right job. So
yeah. So when you uncover a fraudulent claim or defective claim, whatever you want to call it, like, what do you do with it? How do you follow up with it to remove it from the bank of claims and explain to the judge that there's this huge swath of claims we're not going to pay?
yeah.
And then just what's the process for follow-up and for making sure that you don't pay the wrong people?
It's such an important question, and a conversation that I had with another attorney. Gosh, I wish I would have included him in our list of questions, but a conversation that I had just on Tuesday, and he said, you know, it's a real delicate balance of, you know, we want claims, we want a good response, but then at the end of the day, you know, if we realize that we've got a huge amount of fraud in there, then what do we do about it? And what do we tell the judge? And what looked like a excellent participation at the end of the day may not be such a great participation. And I think that's true with an awful lot of settlements out there. You know, the numbers look big. Oh, this is great. What a great result. But at the end of the day, what's being paid out is paltry in comparison to what was filed for. So I think that that's part of that plan that you need to have in place, that contingency plan, Kevin, of what are you going to do when? What are you going to do if? So, you know, our guidance is as follows. You know, first off, I think that going out there and alerting the bad actors that you're on to them isn't necessarily helpful. So you need to have a way to segregate the claims and identify what is a defective claim, which is versus, you know, what is a fraudulent claim, and treat them very differently. You know, if somebody simply, you know, missed checking a box or forgot to upload the proof that they thought they had or something of that nature, that's very different than somebody out there, you know, playing the game of just trying to get paid on everything that's available. So those claims should be treated differently. You know, give the person who made an honest mistake a chance to correct their claim and correct the deficiency and alert them as to the next step that they need to take to cure that is very important. And that's part of the due process, right? But simultaneously, you don't necessarily want to treat the bot farm in Jamaica that same way. So you have to have a process that's designed and flexible enough to accommodate and achieve those goals. You know, look, we love to see participation in settlements, but I think everybody recognizes that it needs to be valid participation, that, we all want to pay valid claims. We don't want to make it a cumbersome process for people. And there's really you need to strike a balance, and there's a way to do it if you're very thoughtful about it and purposeful about it, in striking that balance to where, legitimate claimants have a path that is as, just not burdensome for the sake of being burdensome, thinking that somehow you're being cute enough to capture those bad actors. That's not going to achieve the goal. Again, you've got to have a seasoned team that can take and do this data analysis and has the resources and integrity to ensure that the process has integrity. So, I think that that's a big part of it, Kevin, is it's not treat all claims the same. I know that can wrinkle some noses, but the reality is that a bot farm they're not a class member. They're not a valid claimant. They shouldn't be treated the same. Now, once we know that we're dealing with a legitimate person and a legitimate class member or legitimate claimant, yes, everyone should be treated the same, and there should be no preference between them. But I think that that's where those bright lines exist, Kevin.
Yeah, so it's giving the genuine and the real claimant that just made an honest mistake that led to a sort of a defective claim, if you will, the chance to cure, but making sure that the bad actors and the bot farms claims are all removed from the administration. So yeah.
And don't tip your hand to them. That's not
helpful. So let's move on to our third section, which is navigating some notice programs. Now, I don't want to say I don't want to be negative to our good old U.S. Postal Service. However, are there, when you're doing a direct notice, via postcard, are you seeing problems with delivery from the U.S. Post Office?
Yeah, look, Kevin, I have I've been doing this a long time. I've mailed a lot of pieces. I've probably mailed more than most. I love the post office. Big shout out to Alan at my local post office. I think he should be the grand marshal of the parade. They're sort of an unsung hero, but I will tell you, and I don't want to get political here, Kevin, but I will tell you that there has been a concerted effort on the behalf of some folks to degrade and diminish the post office. They've taken away a lot of their tools. They have staffing issues. They're doing it for a reason. They're politically motivated to try and weaken the postal system, to demonstrate that mail-in voting is not secure or not high quality, and it's cascaded on down through the entire service offering. I think that just recently the post office has changed their rules with regard to postmarks. Not a lot of folks are aware of that, but
how do you mean? I'm not aware of that.
Yeah, Kevin, it used to be that when we as an administrator dropped off the mail, that postmark was
for that day.
Was that day. No longer is that the case. If you do a deep dive on it, Kevin, you'll see that it's when that mail actually hits a automated mail sorting facility that they will put that postmark on there now. So it's not the same. And people need to be aware of that. It can impact everything from whether you're talking about notice to claims to opt-outs. Most objections, they ask that they're filed with the court, but even potentially an objection. You want to exclude yourself from a settlement. So you take your exclusion request and you drop it in the mail and think that you beat the deadline that was, set forth by the court. Well, when's that postmark being applied? It's not when it hits your local post office. It really can be delayed, and we're seeing a huge delay in the mail system. They've removed equipment sorting equipment from these facilities. And it's having a ripple effect through the system. Again, I love the post office. They perform a invaluable job to us all. I think that, mail has really taken a back seat to a lot of the electronic things. And that's okay. I think that there's room for both. But this notion that it's infallible to be doing, printing and mailing is just not true anymore. And I think you need to be thoughtful about notice and what is the best notice practicable, and what's available. And, you can, improve data and come up with legitimate, valid email addresses for folks that maybe you didn't have their email address, and there's ways to go about that. And I think that, having multiple channels, whether it's mail or media or email or all these types of things, you can build layers in that notice program. But it saddens me to say that notice by mail is not what it once was, Kevin.
I had no idea that the post office was being made to do more with less, and that some of those tools and resources had been removed from them.
Yeah.
I didn't know about any of that.
It's very well documented, Kevin, and if anybody's seeing this would like, I've got several articles out there. I provided a declaration to a court a while back, and within just a few minutes, I found about 14 articles where, you've got, senators and congressmen asking questions. What's going on with the mail service? And doing a deep dive in it. There's even, it reached the Supreme Court. And unfortunately, the Supreme Court ruled that they can't be held accountable for purposely misdirecting mail. And that is a tragic thing to think about. So, look, again, am I being overly dramatic? Maybe, but you've got to realize I've got 30 plus years of spending an awful lot of time printing and mailing things and trying to ensure that they're going to the right place. So it hits a soft spot, Kevin.
Yeah, that's unfortunate, but I see how that is an issue, and I would anticipate it's not going to improve. It's only potentially going to get worse with time. Really.
I think that's right, Kevin, and that's an excellent observation, is that, what's the change that's going to make it better? And I think you're probably right. So I think you need to look very seriously at the alternative, methods of notice, and again, multiple layers of notice, so that we are providing adequate notice to people. So.
Agreed on that point. So another question on direct notice, but a different method. So this would be like direct email notices. If you're doing a direct email notice, and you know the class members and you know what their emails are, I assume. We've had these cases, though, where sometimes you also need to augment with social media. Why is that sometimes required?
Yeah, I think that it's a great thing to think about, Kevin. Email takes many different forms. Where did the emails come from? Are they customer emails? Are they promotion emails? Where did these come from? Taking and doing a valid cleanse of those before you send out is very important, because, if you get flagged as a spammer because you're sending to known, trap accounts is what they call them. That's not going to help. So the other thing is people change emails. I've had several email addresses over the years for a lot of different reasons. So while email is an excellent tool to deliver notice, and improving those is very important, I think that, again, this notion of adding layers, Kevin, is very important, because there's going to be people that you miss. There's going to be people that are just happen to be busy that day and don't check their email. And, providing them an alternative means to see that notice can be very important. And I think the courts are looking for that. I think they're looking for a multi-layered approach. And again, every case is unique. Look, if these were direct purchasers and that's where that product came from and there was no other means to get it, sending a couple of notices out on that to those, emails that are high quality probably gets the job done. But a little belt to the old suspenders can be kind of helpful sometimes, especially when, the case is being scrutinized by the court. Then, having a backup, that contingency plan that we talked about, Kevin, of, what do you do if, what do you do when? So,
right. I was just going to say, it sounds like the belt and suspenders approach gives you the best chance of ensuring final approval from the court, and
right.
not having to wait or do social media campaign after you did notice, and now you have to wait 90 more days. Which is another.
Can you imagine being the general counsel for an organization that you've sold the board? Hey, we're going to get this thing extinguished, and now you've got to go back and say, sorry guys, there's a delay.
Right.
This isn't going away. And oh, by the way, hey, we're going to need some more money because now we've got to send out additional notice.
Well, it goes back to my story about the head of litigation having to go back to the GC and ask for, another $1 in another month. Like that's, they never want to do that. So all great points.
Sounds like a good way to end up on Indeed.
Yeah, right. In terms of media campaigns, how was traffic actually measured? Do the impressions really matter, or should there be another focus on the media campaign to prove that you've truly reached the required amount of potential class members?
That's such a great question that they asked. Look, the industry has worked for decades. Since I've been doing this, they worked for decades to beat this notion of impressions and frequency and reach into the heads of practitioners in the judiciary. And I find it to be problematic in several regards, Kevin. I think that I've seen several programs in my career where there has been hundreds of thousands of dollars and millions of dollars spent on notice in the past. And the number of claims that have resulted from those programs in many, many instances has been paltry at best. And I've heard practitioners say in the past, look, that the media program should be disconnected from the response rate, and they really have nothing to do with it. That due process has been met doesn't necessarily mean that there's really any claims in the case. And I find that troubling at best. There's a better way to do it. And the way that we have done it, look, we can come up with a reach and frequency calculation as well as anybody and make sure that we're checking that box. But I think there's better questions to ask, and there's a better approach. And that better approach is, okay, you're spending some money. You're spending some money on a media campaign. What has resulted from it? You have to measure it. And by what has resulted from it, what do I mean? Am I talking about just claims, a raw claim number? No, I'm not at all. What I'm talking about is you're spending money on these impressions and buying clicks in many instances in digital campaigns. Mm-hmm. Now, follow that through. Follow it all the way to conclusion. And what resulted from that? And did you get a valid claim? Or was it just simply the fog of war of these bot frauds and this nonsense, claims and traffic that's at a result. And were those impressions that you bought truly executed upon a live person, or are those clicks just being consumed in the ether? And again, being used by bot farms on the thing. And it's a different way to look at it. And I really would challenge people to change the way they're thinking about these things of, building a program and then, well, we've got this program and we're just going to execute it, blindly and march on down to final approval. And here we are. And we said we were going to spend $200,000 and we spent $200,000. And here's the claims that we've got. Who cares?
Yeah.
What they should really care about is, I spent $1, and when I spent that $1, what resulted from it? Not just impressions, but actual valid being the operative word here, claims. And that is what you should be measuring. Because otherwise, what is the point? What is the point of having a media campaign? Just reach, frequency, impressions?
Yeah. And how do you measure that, though? Would it just be like on the claim form, like how did you hear about the claim? And it was
no, it's actually tracking it using data, Kevin. We can see it from inception, from the point at which we're putting those impressions out there, and then it being clicked on, and the person saying, "Oh, that might be me," and then going to the website, seeing the information on the website, and then filing their claim, or they just simply going right to the claim page, or we can even see the traffic, Kevin. You can see when a impression is being shared. So in other words, I see something online and I'm like, "Hey, Kevin, did you see this?" We can actually see that traffic go through. So you kind of see where it's the old phrase of, and they tell two friends, and they tell two friends.
And they tell two friends, and it snowballs, and then...
That's right.
Yeah. Oh, I see how that would work then. Okay. Very interesting. Yeah. Sure. So, all right. Moving on to our fourth section, technology and call centers. Now, this is interesting. Do call centers rely on humans and AI? Are more call centers relying on AI? Are your call centers relying on AI?
Yeah.
And how do you train that? If so, I assume the answer is probably yes.
Yeah.
How do you train them to answer questions reliably and accurately?
Yeah. So I think that, again, questions that practitioners want to know is where is this work being performed? I think that originally, a lot of administrators had their own call centers. I think that then, cost pressures caused them to look to outsource that. We saw a lot of overseas call center work being done. I think that has its own set of challenges and frustrations with folks. I think there's a lot of cases that don't have agents, period. They were simply these recorded scripts, Kevin, of, how do I know I'm affected? Blah, 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 blah.
Like an automated FAQ.
Automated FAQs. Press 8 to hear the important dates. Press 7 to know, what products were affected. Press 6, what I'm going to get. This kind of thing. And, the reality is when you look at the metrics that people don't spend a ton of time on that stuff. And I've had those frustrations, Kevin. I'm not talking about settlements per se, but it's all the same. How do I know which button I'm supposed to press? Is this where my answer is? I feel like I'm on a little bit of a quail hunt, and I'm looking all over the bushes for my answer.
Right.
But and that's what's caused us to look at deploying technology on these things. That many instances we're not just replacing a person on the thing, because a lot of these cases do not have the budget for a live agent, but we're replacing these recorded FAQs. So now to your question of, well, how do you train them up? Well, we train ours up using the documents. So, that long form notice, the settlement agreement, the court documents, the complaint, and all these things, and building a contained environment, which I think is very important, to provide this knowledge base for the AI agent to respond to folks. And that when you then do that, it needs to be tested. And tested rigorously. I will tell you that we had an instance of we were using an AI agent, and an objector, was making a complaint about the AI agent. And the reality is that we've trained them to be very empathetic, because people want to be heard. And we make sure that we, number one, I think there's some important takeaways here. I think number one, don't be cute. Announce up front that this is an AI agent. We're not trying to fool anybody. Number two, I think that, again, make sure that, the caller's being heard, letting them know that you've been heard, letting them know that you understand the question with that AI agent. And then having a knowledge base to go back and provide a response to them, of, hey, how do I file a claim? Hey, what does it mean to exclude, or these types of things, and being able to relay that information in a way that the average consumer can understand is an important thing, because you're talking about a legal process, and so you've got to be able to break it down to just kind of an everyday man conversation. And I think the AI agents that we're using are excellent at doing this. It's funny because we still capture all the information from these calls, Kevin, and I find myself doing it too. I have people thanking the AI agent at the end of the call.
They forget that it's not a real person.
They forget that it's not a real person, which I think is
it's almost like, you have a live customer service person that you're dealing with that you forget.
That's right. That's right. So, that's the sign of success, right? Is that when somebody feels like they've been listened to, their questions have been answered, and gosh darn it, they thanked them. Yeah, they thanked the bot.
I love it. Oh, that's great.
I consider that a success. So.
I would say it absolutely is. So when you're using AI technology, though, and that's being utilized in any of the administration process, how does it affect the billing structure?
Yeah, it's positively affected it, because we're able to deploy this very efficiently, and most of the cases we still give people the ability to request a callback from a actual person. I think that's an important thing in most cases.
Sure.
So we do that with people, but the reality has been, our experience has been, is that people's questions are actually getting answered by these AI agents, and they're not needing that callback. So that's reducing the cost of administration. In addition to, a well-trained system, again, can answer people's questions very efficiently. So think about this. You have somebody call, they're listening to this pre-recorded call tree of press 1 for this, press 2 for that, press 3 for that. And somebody who's really concerned or has a question, they're going to be on there a while trying to get their answer. What the beauty of the AI agent and the efficiency of it is, you can really interrupt them at any point and say, that's great, but here's what my question really is. And I'll tell you what's kind of, it's a combination of amazing and scary at the same time, Kevin, is what I found with a properly trained agent is that not only do they answer the question that you asked, but so many times they've predicted what your next question is going to be based upon what you just asked, and they'll answer that question too. So when it gets down to efficiency, they're on the phone less, they're getting their answer quicker, they're more satisfied with their answer, And that's really the goal of providing a call center to begin with, is answer people's questions. And if we can do that efficiently, respectfully, empathetically, and get them moving on down the road, well, then we've done our job. So
Yeah. Yeah. So I can see how that would be very effective in managing and reducing costs and not going through the electronic FAQ where you either don't get an answer, you
right.
hang up in frustration, or you can't get a complete answer. And like to your point, even if you're using a program such as ChatGPT, you put in a prompt and it gives you a very detailed answer, and then it says, now if you would like for me to build out this plan or answer this question, and you're
Yeah.
sometimes I think to myself, I haven't even thought about that, but yes, please go ahead and
Right.
answer the phone question. And it just keeps going and
I
going and
know.
going, and
I know.
it's
We're all looking
I'm
over
blown
our
away by
shoulders,
it.
aren't we, Kevin?
Yeah, I don't know. Yeah, it's really amazing how it's impacting all different
Technology continues to really change the
at a more
landscape.
rapid pace as time continues too. It is something, but I do find that it makes the practice of law, and as you've stated, the administration of settlement claims and class action cases, and it can make it much more efficient and lead to much higher client satisfaction, and really, at the end of the day, help reduce costs. So, all right, super interesting. That would bring us to our fifth and final section of the podcast today, which is ethics, finances, and transparency. Now, you were asked, or one of the attorneys that you interviewed had raised the question, where does the interest on settlement funds go, and what ultimately happens with unclaimed funds?
Yeah. I think that's a question that if practitioners are not asking those questions now, they're going to be very shortly. It's something that the court is very focused on. And I think there's a lot of the judiciary that is not pleased with the answers that they're getting on some prior settlements and prior work. Look, I think that, disclosure is key, and being very transparent is key. And, when it relates to the interest on qualified settlement funds, I believe that the ethics and the law are clear. Those
Okay.
funds have been created and set aside for the benefit of the class. And the only way that those funds shouldn't be going to the benefit of the class is with transparency to the court and approval from the court. If that's not what's happening, I think that there needs to be some serious soul searching or investigation into that. The unclaimed funds, most of the time there's guidelines for an administrator in the settlement agreement as to where those funds, should go or are going. It's a great use of cypre. It's not the only use of cypre, and cypre shouldn't be a crutch for distribution of funds. But at the end of the day, you hit diminishing returns, Kevin, where the process of a redistribution costs a certain amount of money to execute, and you'll hit that point where now all of a sudden it's just not efficient to keep doing redistributions in that. So having a redistribution process is great, but at some point it needs to stop, and you need to wrap things up. So again, that's excellent use of cypre, and again, that's all under the supervision of a court, knowing where the funds are going. And that's really what it comes down to, Kevin, is transparency and being transparent and letting people know what's happening. And most of all important, letting the court know, because, it's under their supervision that we're doing all of this. And I don't think anybody that's out there with a settlement that the parties want to be, pulling the wool over, the court's eyes.
Well, no. Do you ever have any instances where the company, it has enough money. You know, the company is solvent.
Mm-hmm.
You
Mm-hmm.
know what their annual revenues are and things, and they have the money, and you just wait until all the claims are collected,
Mm-hmm.
and then they just write a check. It doesn't necessarily go into a separate bank account,
Yeah.
and then
So
there's
direct
unpaid.
payment. Yeah, you
Yeah,
bet. So there's I'm not a tax attorney. I don't play one on TV. There's tax
right.
reasons as to, the way these things are working with a
Okay.
468B
Yeah.
qualified settlement fund account. But we have seen instances where distributions are being made directly by defendants.
Yeah.
Sometimes they're taking the form of account credits, Kevin, and that's something that, look, an administrator can provide, a deck of claims that are valid claims back to a defendant and say, okay, these are the people that filed claims, and these are the people that need the credit to their account or something of that nature. Again, these is not one size fits all, and there's a lot of different roles that a lot of different people play in these things. And certainly that can be a component to it, of it. But I would say that more often than not, we're setting up a 468B qualified settlement fund, and then those funds are being deposited in there, and then that's the funds that we're using to send out to valid claimants.
Yeah, that's the standard operating procedure. So,
It really is, and I think that making sure that you have adequate accounting of those funds and is very important. So there's banks out there that we work with and partner with, to make all of this happen, and they're really, really good at what they do, and they know this industry and they know how to get these funds sent out in an efficient, transparent manner. And that's really, kind of the thing that needs to happen when you're asking these questions is, who are you using? How are you doing it? What's their experience? How many of these have they done?
yeah.
You don't want to be the guinea pig. Hey, we'd always like to get into this business. Okay,
Yeah.
great. Did you hire a seasoned team? Do they know what they're doing? All good questions asked. The same questions you should be asking your administrator.
Yeah. Okay, Jim. Last question of the show today, and thank you for all of your time and your incredible insights. I think this has really been a great, robust program. But to close out the show, let's talk about pricing and costs. So I know that judges heavily scrutinize administrative costs.
Yeah.
So how do you ensure that your pricing is credible and protect the reputation of the plaintiff's attorneys while hiring you, but also run a profitable business?
Yeah. No, it's a great question, Kevin. I think that what we try and do, again, you're just going to hear this from me again with regard to transparency. I think that being transparent with our clients as to what we're charging, how we're charging, where we're making our money, I think is the thing that we are trying to do different. We're letting people know up front what they're going to be charged, how they're going to be charged. We're also trying to make it in such a way that we don't have these difficult conversations. And, I think there's some folks out there that are interested in just securing the business, and, they'll deal with the billing later. And, I think that's a recipe for an awful lot of difficult conversations. And, that's where the GC's, pulling their hair out going, what do you mean it's going to cost this? And then the answer is, well, the claims rate was so high, or the administration was so difficult, or, this complication or that complication. You just see it time and time again. And why does every settlement have this, complication? And I think it's that, look, we all want to, make money. We're not doing this as a nonprofit, but there's a way to do it ethically. There's a way to do it transparently. and to have a very clear understanding up front of what's being charged, how it's being charged, when it's being charged. It's a conversation that nobody wants to have, but I think it's an important conversation to have and have that very clear understanding up front.
Yep, I think those are all great points to make sure that you are, of course, coming across as, ethical and transparent as possible.
Yeah.
So, all right. Again, Jim, thank you so much for your time today. I really appreciate it.
Yeah. No,
You
thanks
really,
for
know
having
your
me,
stuff.
Kevin. Yeah.
You really do. So,
I appreciate that. I
yeah.
appreciate you and your audience's time, Kevin.
Yeah, definitely, definitely. So I have a feeling that once this goes live, which will be on the Stratton Group website, I'm sure it will be on the Fidexis website and on LinkedIn, and it will also be on about the top 10 most popular podcast platforms: Apple, Spotify, Stitcher, and wherever you listen to your favorite programs.
Go, Kevin,
However,
go.
if somebody would like to contact you directly, what would be the best way to reach Jim Prutsman?
Yeah, probably the best way is by email, and I'm james@fidexisgroup.com, and that's FIDEXIS.
That's terrific. And last but not least, I want to thank the audience and all of my followers for listening to this very robust and insightful program. If you want to get a hold of me to discuss any of the litigation, finance, or insurance products that Stratton Group offers, you can reach out to me at Kevin S. at Certum Group, CERTUMGROUP.com. So again, Jim, thanks for your time.
Thanks,
And
Kevin.
look forward to working with you again soon.
Yes, sir. Thank you.
All right.